Welcome, welcome, welcome. Welcome in, everyone. Welcome to Care Concierge with CarePatrol, where education is the heart of everything we do. We educate patients and families about options for care and how to find those options, how to qualify or pay for those options, and when those options include retirement communities, assisted livings, memory cares, or in home caregivers. Care Patrol may receive a commission from those entities, but we advise folks on all sorts of providers from primary care physicians to uh, home health companies to skilled nursing and rehab facilities to elder care attorneys and such as that. We have today a frequent presenter with us, Bill Nolan, who has presented many topics and is presenting today on a topic that was requested last time he spoke with us. So it's a deeper dive into trust. Now, Care Patrol is accredited by the Alabama Board of Nursing and by the Alabama Board of Social Work. And each of those boards say that this course qualifies for 1.0 contact hour. Now, in order to receive the contact hour, in order to receive a certificate, you must do the online evaluation. This is true if you're live with us today, or if you are doing this via YouTube at some later date. The evaluation link is SurveyMonkey. And for those who are live, who may be driving or reading, doing something else on their laptop while we're here with you, I'll read the evaluation link now. Remember, you must do the evaluation to receive the certificate. And the evaluation link is https://www.surveymonkey.com/lowercase r/ all uppercase letters and numbers K G as in girl L9 B as in boy F as in female 9, and we'll give the password at the end. So make note of the link and just know that we'll give the password at the end today. Listen out for that. And do please know that we encourage discussion. We'd love to hear your comments. Certainly, we want to answer any questions you may have about the material. And our presenter, Mr. Nolan, Bill Nolan, is gracious enough to allow me to interrupt him with your questions. So please do let us know or let us hear from you. And without further ado, and greetings to those of you in Pinson and Montgomery. And isn't it just a lovely, almost fall day today? What a treasure and what a relief. Bill, thank you so much for being here. And I'm excited to learn more about avoiding probate. Thank you so much.
My pleasure. Thanks, Sean. I appreciate always being invited. It's nice to speak to folks and get their questions. So, like Sean said, if you have any questions, don't hesitate to ask them. If we can't answer them right now, you can always text or email us a question, and we'll get back with you personally today or tomorrow. So, here's where we are. The last time we talked about avoiding probate, and many of you were with us when we had that presentation. So this is going to be sort of like a part two of the avoiding probate presentation we did a couple of months ago. For those who are new today, I don't think you will have missed much because we're going to sort of recap what we talked about the last time before we jump into the deep dive, as Sean said, about trust. Last time we talked about that it's not a question of if we die, it's a question of when we die. The mortality rate for the human race is running right at 100% still. So it's not a question of if, it's a question of when. The real question is what kind of plans are we going to have in place when that time might come? Lawyers make a lot of money when people die without having plans in place. So I guess by teaching people to have plans in place, I'm putting a curtailment on my own income, but that's okay. Um, the We talked about last time that there are three ways that assets will pass when you die. The first is joint ownership, the way many husbands and wives own their home. By beneficiary designation, if you have an IRA or a 401k or a life insurance policy, you've chosen a beneficiary there. And if you don't have a joint owner on an account or a beneficiary on an account, it's just your asset, whether it's a house, a car, bank account, stock, bond, mutual fund. If it's just your asset, that's what they call a probate asset. So a lot of people talk about probate, but what is probate? And we talked about that a little bit last time, but just to summarize again, when a person dies, their stuff has to go somewhere. You can't take it with you. That stuff is collectively called an estate. Almost everyone has one. If you're working, you probably have a bank account. You probably have a retirement account. You probably have stuff you've accumulated in your apartment or your home or your car. Things like that's considered an estate. It doesn't have to be millions and millions of dollars worth. Now, a will lets you tell the world who gets your stuff when you die. Without a will, well, the state has a law, has provisions in place as to who will get your stuff when you die. So you could say, well, the state has a will written for me. They do. It may not be the will you want or need, but they do have a will. It's in the state code. This process called probate is the process the court imposes, whether you have a will or not. It imposes it on your executor and your next of kin, your loved ones, to administer the transition of your stuff from you to who gets it next. That's called probate. It takes about a year and it can be avoided with some pre-planning. Many people don't know that, but it's the truth. Now, there are two types of probate that the state will impose upon families. The first is called testate probate. We talked about this before. And the second is called intestate probate. Testate probate is the process that they impose on your estate when you die with a will. Some people are of the impression, I guess, no telling why, that if you have a will, your estate avoids probate. And that's not true. If you have a will, your estate still has to go through probate. It's just a faster, more expedited, more efficient, and cheaper probate process if you have a will than if you don't. There's still some court oversight, but not nearly as much as if you die without a will. It's interesting, even if you have a will, and even if your will disinherits your next of kin entirely, the next of kin still have a chance at the very beginning to challenge that will. They can say, I think that will's fraudulent. I think he was out of his mind when he signed it, whatever. So, your next of kin are given an opportunity by serving them with notice before your will is even admitted to probate. So that's a weakness in dying with a will, is it's easy to challenge a will.
And we have a question, Bill. It's Renee
Yeah.
Farmer is asking, I'm wanting to put my home and business in a trust. Someone said to put it in a special trust to avoid Medicare and Medicaid coming after you. What kind of trust is that?
Well, you're in the right place. That's exactly what we're going to talk about. So sit tight and we're going to get into that for you. Thanks for asking that question. It's a good lead in. Your executor, if you have a will, you name an executor. They're given what are called letters testamentary. That allows them to transfer assets back and forth, to open and close bank accounts, to make distributions, to deal with the IRS and that sort of thing. However, even with a will, the estate has to be open 6 months before um, any of your loved ones can get their hands on what they inherit, because creditors have a what they call a priority to get paid before the beneficiaries get a dime. So yeah, dying with a will is better than dying without a will, but it certainly is not the easy way that some people might think it is, because your creditors are, they're going to have a shot at your stuff before your family gets it. Intestate probate, on the other hand, is the process when you die without a will. That's where the state says he died without a will. That's okay. We're going to impose this will that's in the state code on his estate. Now, instead of having an executor appointed, an administrator is appointed. The administrator works for the court, more or less, because they have to seek the court's approval to do anything and everything. It obviously costs more money when you die without a will, because the administrator has to go back to the court and ask permission many times. And each of those court appearances has a court cost and a lawyer's fee imposed on it. So you can see it's more expensive to die without a will than to die with a will, because somebody's going to be paying for those court costs and those lawyers' fees and that sort of thing. It also takes about twice as long. So anybody who thinks dying without a will is a cheap way to go is completely misinformed. It imposes all kinds of undue expense and hardship and delay on your family, and it doesn't have to be that way. So if you have somebody who thinks that dying without a will is the way they want to go, you need to have a word with them. It's definitely not. But what if, let's just say, what if you wanted to avoid this probate process entirely? Is there a way to do that? And yes, there is, and that's what we're going to talk about for the rest of today. Remember, there are three ways that assets pass when you die. Remember, joint ownership. That is, you and your spouse own your home jointly, and whoever dies first, well, the survivor gets it outright. It's free, it's immediate, it's the best. But joint ownership is not available for every asset. The second way assets pass, by beneficiary designation, that could be on a bank account, TOD account, POD account. It could be an IRA, it could be a 401k, it could be investments, or it could be life insurance. You've already chosen who's going to get that asset when you die by naming them as a beneficiary. And the third way assets pass, that is, now if you don't have a joint owner or a beneficiary, it's just your asset, it has to go through probate. So how can you make sure that all of your assets are either number one or number two, but not down here at number three, where it would have to go through probate? And many people choose trust as a way to achieve that goal. A trust is a legal entity. That's a weird term, but a corporation is a legal entity. An LLC is a legal entity. A partnership is a legal entity. Those are artificial, uh, 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 I guess, artificial creations where they have rules and rights and they have obligations. A trust is a legal entity, just like an LLC. There are three parties in every trust. There's the person who creates it, that's called the trustor. There's the person who manages it, that's called the trustee, and the person who benefits from it, they're called the beneficiary. Sometimes, many times, the same person fills all of those roles. They create the trust, they manage it while they can, and they benefit from it while they can. Now, trusts are usually created to hold assets for a period of time. In many cases, it's the lifetime of the trustor, the person who creates it. It might even extend beyond their life. Trusts are usually created to manage assets for someone's benefit, like the trustor, the person who creates it, and it might be for the trustor's children after the trustor's gone. And the trustee is the person chosen by the trustor to manage those assets. In many trusts, the trustor, the person who creates it, is managing the assets while they can. And then if they're disabled, they've appointed someone as successor trustee to step in to manage them after they can't any longer. So, yeah, in very simple terms, think about a trust almost like it's a safe, like it's one of those big gun safes or a bank safe that you have. A trust is like a safe in many ways because just like a safe, a trust holds your assets safely. No one can get to the assets that are in the trust but the person with the combination, with a safe combination with a trust. The person who is named trustee has the right to access those assets. And you get to decide who gets access to the safe when you die. You get to decide who gets assets to the trust when you die. So a trust is in many ways like an artificial safe in a way. But remember this, if you have the nicest safe in the world in your basement, but you've left your jewelry on your dresser, that safe isn't doing its job. It's expensive, it's nice, but it's not doing the job that you paid for. So you have to put your assets into the safe in order to get the benefits from that safe, and you have to put your assets in your trust to get the benefits from the trust. And that's the biggest single mistake I see lawyers making. And I've been doing this 40, 43 years. So I've seen a lot of trust that other lawyers have done, and it's a very nice trust, but they don't help the clients move the assets into the trust. And that's the mistake because the client doesn't know that. So we really do, I think, have an obligation to help our clients understand how to move their assets into their trust after we've created the trust for them.
Bill, we have a question. Anna
Yeah.
Clardy actually says she'd like this asked later in the session, but I think now really is the time. She says, for the average person who may have some assets, a normal amount of debt, and an average financial situation, which she says personal owners, non commercial real estate property, less than 20K debt, and several life insurance policies. What are the benefits to having a trust instead of a normal will and testament?
I hear you. Well, I think the biggest single benefit to having a trust is the flexibility that you can gain. You can be much more specific about how assets might pass if things happen in the future than you can with a will. You create a trust now while your kids are still young. You don't know how they're going to turn out, who they're going to marry. You don't know if your grandkids are going to have special needs or not, or whether they have drug problems or not, or they need some extra help along the way or not. You don't know whether your kids are going to get a divorce or not. A trust can allow you a lot more flexibility than a will could. Also, if you own property in more than one state, or you decide to buy a place in Florida or Tennessee or North Carolina or somewhere, or you inherit property from a family member in another state, you have to go through probate in every state you own real estate, whereas with a trust, you don't. So there are some real tangible benefits to a trust. And I think the other benefit is you don't have to worry about a trust being challenged like you do with a will. If there's somebody that comes along and wants to challenge your estate. And we're going to talk about that in a minute as well. Um, so, a trust. How does a trust avoid probate? Well, remember, there are three different ways you can own property. And the second was beneficiary designation. A trust names beneficiaries. You have moved your assets to the trust. Now, the trust technically owns those assets, and the trust has a beneficiary for each of those assets. So you've basically taken an asset that would have to go through probate and created it a way that you can put a beneficiary on that asset by using a trust. Um, that's how it avoids probate because it names beneficiaries where the trust says, at my death, the assets in this trust will pass to Jane and Joe, or to my kids, or to my grandkids. You've avoided probate by using a trust, whereas if you'd had a will, your estate would have to go through the probate process. Um, Trusts have been around for a long time, by the way. They're fairly new in terms of us talking about them because up until fairly recently, really wealthy people used trusts, whereas The rank and file of us, well, we were either happy not having a will at all, or we felt like a will accomplished those goals pretty easily. But as people's assets have become more complicated, trusts have become more available to the rank and file than they ever were. And it's really not a question of how much you have, as it is the character of your assets that make a difference. We're going to talk about that in a second. But trusts go all the way back to the Middle Ages, when they were created, by the way, during the Crusades. When a landowner he's decided to go to the Middle East to fight the horde over there, to fight the Crusades. And at that time, real estate was the mark of wealth. And earls, or kings, I don't know what they call themselves, but they owned the real estate. And they knew if they went to the Middle East to fight, there was a good chance they wouldn't come back. So back in those days, the eldest son would always inherit the real estate, the land, the property of the person dying. I know it's not fair, but that's the way it was. So this Earl, who's going to the Crusades and fight the horde in the Middle East, he went to the bishop and said, "Bishop, I'm going to transfer all of my real estate to you to hold in trust for me. If I come back from the Crusades, you're to give it back to me. If I don't come back from the Crusades, you're to give it to my eldest son." So that was the creation. That was the way trust came about. So they go back a long way. Modern trusts are not nearly quite so dramatic. Uh, a modern trust can be created very simply, and it's created by you setting up the trust, naming yourself as the trustee, and naming your kids or your grandkids as the beneficiaries after you're gone. You can delay gratification for your kids and grandkids. You can encourage them to go to college or trade school. You can you could stretch out money over their lifetime, almost like putting them on an allowance, if you like. You can speak to the situation. What happens if one of my children dies without children? What happens if one of my children gets divorced? You can deal with all of those issues as well. Modern trusts are particularly valuable if you own real estate in more than one state, because if you own real estate in North Carolina and Alabama, or Mississippi and Alabama, you have to go through probate in both states because you own property in both states. But if you have a trust that owns those properties, you don't have to go through probate in either state. So it saves you years of time in court and years of court cost. Great way to do it. And I've seen families who they don't learn they're inheriting their parents' stuff until they're in their 60s or 70s themselves. So it's never too late to think about creating a trust, whereas a will-based plan might have been perfectly adequate up until you've inherited real estate. Now it's time to maybe expand that to a trust.
Bill,
Uh,
are you saying the probate process could take a year?
Easily. Oh yeah, easily. Sure could. And if you own property in, say, Florida and Alabama, you open your probate in Alabama, and then you open what's called ancillary probate in Florida. And the ancillary probate Florida is there just to deal with the real estate down there. So the Alabama probate case has to stay open until the Florida case has dealt with the real estate, and then the Alabama case can close. So it can easily take a year.
Wow. And how much
And
would it cost?
I would say these days, $4,000 or $5,000 is customary for the probate process.
Dang,
Uh, so it's not cheap, and it's somebody has to do the job. It's an honor to be named an executor, but it's a job. So unless you're willing to work pretty hard for the next year, being named an executor is not an ideal situation. And many times when you name an executor, you're not thinking about what their family might be having to go through when the time comes for them to be an executor for you. So if you name an older child as an executor, uh, well, they may be dealing with their own kids getting married or having children of their own, or their spouse may be getting sick. So there are all sorts of things that you've got to consider that people don't think about. Uh, I also see the situation. This is this is really kind of patriarchal. But let's say you have three sons and a daughter, and the daughter's the youngest. Now you're getting older, and your daughter, not your three sons, but your daughter is the one who's taking care of you, who's helping you shop and helping you clean and helping you go to the doctor and keep up with all those tasks around the house. And yet your will says your oldest son is your executor. Why is that? Age has absolutely nothing to do with the duties that an executor has to fulfill. It's sort of this traditional kind of thing. And obviously the sons don't have any input or insight into your situation. Your daughter does, so she should, in many cases, be your executor. But for whatever reason, people don't think like that. They say, "Well, my son's the oldest, and he's going to be my executor." But let me get off my soapbox. Uh, Trusts are also great for famous people. You know, you don't want your family laundry being aired out in the public forum, but that's what a will is. A will is a public document. Anybody can walk down to the courthouse and say, "Let me see Mr. Jones's will." They have to show it to you because it's an open record. You know, it's a you can see anybody's will. Well, a trust you can't. Only the people who benefit from your trust get to see the trust. So if you have special needs kids or you have a child with a gambling problem or you want to disinherit someone in a will, everybody can see that, but nobody can see it with a trust. It can be great for second marriages, third marriages, fourth marriages. You know, you want to take care of all the stepkids, but how do you do that with a will? Because, you know, a will can be uh, after the death of the first spouse, the surviving spouse can draft an entirely new will and disinherit those kids from the deceased spouse. With a trust, you can be much more restrictive in that regard and take care of all the kids, regardless of what happens, who dies first in a second marriage, how much time goes by between the first and second death, whether the surviving spouse remarries or not. You can deal with all of those issues. Uh, and second marriages with stepkids, those are the ones where you really see will challenges. They're the ones who cause a lot of legal expense out there.
So, for example, in a trust, you could say you would leave everything to the spouse on your death,
Mhm.
and then you could specify that on that spouse's death, everything goes to your children. Is that what you're saying?
Right. You can specify that you can even say that at the death of the first spouse, this trust becomes irrevocable. So the surviving spouse can't change it.
Okay.
You, so you can be very specific. You can't do that with a will. Uh, and you know, you've heard of the casserole brigade. You know, when the wife dies and the grieving widower is there, and the women show up with the casseroles, and I've heard that more than once. So there's a good chance that spouses will remarry at some point, regardless of their age. And if they do, that can really throw a monkey wrench in the plans that you've put a lot of effort and maybe cost expense into.
How much does a trust cost?
A trust, you know, it's interesting because when you have a will, you're paying for the will, and you're also somebody's paying for the probate, you know, in the future. A trust is less expensive than a will plus the cost of probate. And it's much less expensive if you consider the time involved because you don't have to spend a year in court with a trust. You do with a will. So many people, though, will say, well, I'm paying the cost of the will. My kids will pay the cost of probate, which they will. Some parents will say, well, I want to just take care of it so my family doesn't have to. A trust is a better way for them to go. Um, yeah, I would say everything all inclusive, comprehensive. A trust is probably $5,000 for a married couple, and a probate would be $5,000 plus the cost of the will-based plan on top of that. So you can see it's a little bit cheaper to go with a trust than it is with a will. Um, and either one can be changed, amended, revoked down the road as well.
Huh.
There's some common misconceptions that come up about trust, though. I wanted to touch on those. Are they legal and enforceable? Aren't they only for rich people? We talked about that. Are they confusing? Are they expensive? We just talked about that. Um, a trust is legal and enforceable in all 50 states. So a trust that's legal in Alabama will be legal in Hawaii and vice versa. Trusts aren't really for rich people so much as maybe their need is defined by what you're trying to accomplish. If you have a very small estate, a trust might not be necessary. But if you own property or might soon own property in more than one state, a trust would obviously be necessary. If you have family dynamics that you don't want other people to see, a trust might be better. If you're in a second marriage, a trust might be better. Uh, it depends on whether they're confusing or not by how well your lawyer explains them. We do a good, I think we do a good job explaining how trusts work and why they're important and what everything is designed to accomplish. If you walk out of our office and don't understand what you have, I haven't done my job effectively. Are they expensive? Well, $5,000 is a relative number. That's expensive to me. But if they save your family a year of time and $5,000 down the road, well, they're a good trade-off for that. So, uh, who knows? Expense is relative, right?
Miss
There's,
Johnson has a question
yeah.
asking, is a trust a better option if you are not married but have children, or would a will suffice?
Again, it would depend on the specifics of your estate. I think the way you would do that is you'd meet with a lawyer and explain to the lawyer what your goals are for your estate, whether you have charitable bequests you want to make, whether your kids have any issues in their own marriages or your grandkids have any issues that need to be addressed. And a lawyer who drafts wills will also draft trust. They don't lean one way or the other. They're going to explain to you a trust is a tool, a will is a tool. We just want to find the right tool for this job, and we think a trust is better for you or a will is better for you, and see what they have to say. Hard to know just in general without digging a little bit deeper. Uh, there are three kinds of trust out there that you need to know about. There's a revocable trust. I'm sorry, I went too far there. Uh, Revocable trust, and that's by far the most common you'll see. There's an irrevocable trust, and there's a testamentary trust. Those are the three broad categories of trust. Now, revocable trust, revocable living trust are by far the most common. If you go out and ask 1,000 people on the street who have trust, what kind of trust do you have? I bet 990 of that 1,000 would say we have a revocable living trust. That's how common they are. They avoid probate. That's their primary goal. They can last for decades. If your beneficiaries are minors, you can stretch out the payment over decades. They're private. Nobody gets to see what's going on but your beneficiaries. The only downside to a revocable living trust is there's no Medicaid protection. That was a question that came up a little earlier. Irrevocable trust, on the other hand, do have that Medicaid protection benefit. The 5-year look back rule that we hear about. The 5-year look back rule says that any asset that you transfer out of your name has to be out of your name for 5 years in order to have Medicaid protection. Well, with a revocable trust, yeah, you're transferring it out of your name for probate purposes, but you're not transferring it out of your name for Medicaid purposes with a revocable trust. But with an irrevocable trust, you are. So if you create an irrevocable trust, it has to be in place for 5 years in order to gain that asset protection, but it's protected from that point on out. Now, Medicaid trust, irrevocable trust are great if you're older. By older, I mean in your 70s, 80s, 90s. Younger than that, I wouldn't recommend a Medicaid trust or an irrevocable trust because they're not flexible enough for most families. They're really designed for situations where the owner of the asset is really no longer actively managing the asset. They're just kind of coasting. Maybe their kids are already involved in the financial planning or financial management. Um, the irrevocable trust does cost more to set up because it has to be much more restrictive, and you don't want to make a mistake when Medicaid's concerned. One of the downsides to an irrevocable trust is you can't be your own trustee. Now, you meet a 75-year-old guy who's been managing his assets and been in charge for his whole life, and you say, unfortunately, Mr. So and so, you can't be your own trustee here. you get a knee-jerk reaction from a lot of people. Well, I don't want that kind of trust. They have to stay in charge, which is kind of ironic because the more you hang on to your asset, the more vulnerable it is to Medicaid. If you let go of some control, you can also gain some Medicaid protection, but sometimes it's hard for people to see that.
We have a question.
Yes,
Huey asks if the will and trust are similar in cost, but the trust saves from probate, why would a will ever be a better option?
it wouldn't. It really wouldn't. I think people are much more familiar with wills than they are with trust, and they just sort of lean in that direction. But you're right. If you had the choice, if everything else was the same, a trust would always be a better option. Even if you only owned real estate in one state, a trust would be a better option.
I have a stupid question, Bill, which I've
I
wondered
doubt that.
forever. What does revocable mean and what does irrevocable mean? Those were, I mean,
Great
what do they
question.
mean?
So a revocable trust is a trust that you create. Sean creates his own revocable trust, but he retains the right to revoke it down the road. You can have a trust in place, but 5 years down the road, your situation changes. You say, you know what? I don't need that trust anymore. I'm going to revoke it. Boom, it's done. It's
Okay.
it's revoked. But with an irrevocable trust, when you put an asset into it, it's a one-way street. If you decide, and this came up with us years ago, old farmer wants his farm to go to his two daughters. He sets up an irrevocable trust so he can get his veterans benefits and his Medicaid. And we transfer the farm into it. 5 years goes by and he develops dementia. He calls us and says, I want to revoke that trust. I've met a lady and she wants me to leave the farm to her. Well, you know what? It's irrevocable. I'm sorry, you can't do that. It's a one-way street. Um, so it's great for people with dementia because sometimes elder financial abuse is just rampant these days. And any kind of restrictions you could put on the transfer of assets for your parents or grandparents is a good thing. So irrevocable trusts can oftentimes help for those situations as well.
Okay. Got it.
Now, there's a third type of trust, other than the revocable and the irrevocable, and it's called a testamentary trust. You don't see those nearly as much as you used to, um, because, well, for one thing, they don't avoid probate. What's the point in having a trust if it requires probate to create? And that's exactly what a testamentary trust requires. It's created within your will, so you have to probate your will just to create your trust. It's nuts. Nobody does them anymore. Um, they were much more common way back when than they are now. They were more common when men were the earners and the women were the housekeepers, and the man wanted to control beyond the grave how his widow could access money, so he would create a testamentary trust and put her on a lifetime allowance. So you don't see that nearly as much as you used to. If somebody tries to talk you into a testamentary trust, keep moving. Now, a will can be challenged. We talked about will challenges. Can a trust be challenged? Well, a trust can be challenged for the same reasons a will can be challenged: lack of capacity, undue influence, and the document itself is invalid or effective. But the difference is, remember, a will has to be admitted to probate, and that puts a big target on it. A trust doesn't get admitted to probate, so there is no target to. So people who would otherwise challenge a trust don't have any forum in which to challenge it. So you don't see trust being challenged nearly as often as you do wills. Which is a good thing because it saves the family money and keeps the asset value high and all that. Uh, so a trust is, if you have family dynamics that would suggest somebody's going to challenge it, a trust would be a better way to go. Slam dunk, better way to go. And remember, I'm going to drag this back into the conversation one more time. There are three ways assets can pass at death: joint ownership, beneficiary designation, or sole ownership. We talked about all of those in exhaustion. But someone brought up the point: what if your estate's fairly nominal? What if um, you don't really think that a trust is affordable, or maybe it's more complicated than you might need? but you don't want your estate to go through probate either because you don't want your kids or grandkids or spouse to have to deal with a year of time in court and $5,000. Is there a third option other than a trust, other than a will-based plan that I might consider? Well, for certain estates, yeah, I think you could consider a third option. Um, with simple estates, if you can find a way to juggle your assets so that either joint ownership of assets controls or beneficiary designations can control, you've avoided probate, or you've avoided likely the situation where probate would be necessary. I would still have a will, but hope that you can avoid the probate process. For example, if you own your home jointly with your spouse will inherit that property if you die first, and you'll inherit it if your spouse dies first. You've avoided probate on that. Now, when you become a widow or widower, well, you need to deal with that, but you can add your children as joint owners to your deed at that time, if you like, by using a process called a life estate deed. Life estate deeds are so flexible and so valuable. Everybody should consider a life estate deed. What a life estate deed is a type of deed that says, I own my house for the rest of my life. But at my death, it automatically and immediately passes to my kids. They don't have to pay anything to make that happen. They don't have to file anything to make that happen. It's automatic and immediate. A life estate deed also, addition to avoiding probate, a life estate deed, if it's in place for at least 5 years, will protect the house from a Medicaid lien. So talk about a benefit. A life estate deed might cost $300, and if it protects your house from Medicaid, how about that? If it protects your house from having to go through probate, that's $5,000 you've saved right there. So life estate deeds are great ways to deal with real estate, and it doesn't have to be just your home. It could be family property you've inherited. It could be farmland. It could be commercial property for that matter.
Wow.
Also,
Yeah, we have a question.
okay.
Ms. Clardy says, did you mention how much it costs to set up a trust? I understood you to say it could take about 5,000 to release a trust upon death, but do you know the average cost of getting a trust set up and safely, comprehensively established?
So the $5,000 number I threw out was the cost to create an entire trust-based plan for a couple. That includes the trust agreement itself. It includes what's called a trust declaration, a certification of trust, all the transfer documents, deeds, assignments, all the transfer documents to fund your trust. It also includes what's called a pour over will. It includes a power of attorney, all of your healthcare related documents, including your HIPAA waiver and instructions for your trustee. That's what the $5,000 gets you. In terms of annual maintenance, well, we don't charge anything for that. Your trustee is the one who's maintaining the trust. And if you're the trustee, you're not charging anything. You can provide in your trust that your successor trustee is entitled to a fee, but many times the successor trustee is your child, and they're not going to charge anything anyway. There's no automatic expense to keeping a trust in place. In other words, it would be whatever your trustee might charge, and if you're the trustee, you're not going to charge anything.
So there's no liquid capital you have to fund a trust.
No, not
Okay.
at all. So let's say you've dealt with your real estate with the life estate deed. What about your other assets? Well, most people have two pots of money as they get older. Their liquid assets, that might be bank accounts, investments, and an IRA, and their real estate. Those are where their wealth is. Well, the life estate deed takes care of the real estate. What about the liquid assets? Well, you can use transfer on death or pay on death designations on your liquid assets. That's putting a beneficiary on your bank account or a beneficiary on your investment account. It says, at my death, I want the bank to transfer this asset from my name to my daughter. That's called transfer on death, TOD. Or I want the bank to pay on my death, POD, this bank account to my daughter. So you can move assets with TOD or POD designation without having to go through probate. Easy, cheap, free. You don't have to pay a lawyer or anything. With other types of investments, you might have to have a beneficiary assigned, like with an IRA. But again, you can change your beneficiary whenever you want to, and you can have one child or all your kids, grandkids named. It's pretty flexible. So for simple estates, you don't have to really worry about a trust or a will-based plan. You can use joint ownership with real estate, life estate deeds with real estate, transfer on death or pay on death designations with liquid assets, and beneficiary designations with other assets, and likely avoid probate completely. So if you have a modest estate, yeah, I think there are ways that you can manage that modest estate so that you don't have to worry about the expense of a trust or the expense of having to probate a will. But I think in summary, just remember that a trust is less expensive than paying for a will and paying for probate. It's a lot faster and it's more private. It's much more flexible than having a will. Now, there are no tax benefits or tax consequences to having a trust. It's tax neutral. So, in terms of having a tax motivation to create a trust, there is none. It doesn't provide you any benefit or it doesn't provide you any consequence. Taxes would really have no bearing in the decision. Um, Trust, though, avoid probate in every state where you own property. So if you happen to be lucky enough to have a beach house and your house here, you've avoided probate on both of those. And you could be much more flexible about who gets what and when and under what circumstances with a trust than you can with a will-based plan. Um, Life estate deeds are great. I leave my home to my kids when I die. That's great. But what about if your kids are married to somebody who you don't like? Well, a life estate deed is a one-way street too. It's going to go to your kids when you die. If they predecease you, their interest is going to go to their beneficiary. So if your daughter's married and you don't like her husband, if she dies before you, there's nothing you can do to reel back in that life estate. Her husband, her widower, is going to get her interest when you die. Now that may not matter to you because you'll be gone, but some people say, I don't want him to get it. Well, if you really don't want him to get it, a trust might be a better way to go because the flexibility again. With a trust, you could say, I leave my home to my kids when I die. However, if either of my kids have predeceased me, his or her share won't go to her or his beneficiaries. It will go to the survivor of my kids. So you can sort of disinherit people with a trust, whereas you can't with a life estate deed. Uh, well, that pretty much sums up our time today. Um, there's a link here at the bottom, how a revocable living trust avoids probate. Uh, that link, I think if you click that link, it will take you to Sean's survey. At least that's the way it's supposed to work. If you
Right.
click the link for our website, it'll take you to our website. You're welcome to poke around there. We've got a lot of articles there about all sorts of topics, and we'd love to have you visit. If we can answer any questions for you, Jennifer and I are available anytime. Shoot us an email, call us if we can help you. If you're sitting down with a family in your whatever occupation you might have, and a question comes up, if we're available, we'll answer it right there on the phone. So don't hesitate to call us if we can help. I appreciate your questions. Happy to answer any more that you might have in our few minutes left.
We've got several. Christy Steffs asked if beneficiary designations can avoid probate, and you've already designated multiple beneficiaries in a will, what would be the benefit of changing it to a trust?
Well, a will, does name beneficiaries, but a will has to be probated in order for that to be triggered. And that's the probate process that we're trying to avoid. So if you say, I want my church to get 10% of my estate, in your will has to be probated in order for that beneficiary to get their money. If, on the other hand, you say to your fidelity advisor, I want to put my church on my IRA for 10% of my IRA, it's going to go to the church immediately upon your death. You don't have to open probate to make that happen. So beneficiary designations are much more efficient, effective, and cheaper than having something named in a will.
Well, the other questions were actually people saying, thank you. I needed this. Thank you so much.
Sure.
Great presentation. One lady said, this was funny. My husband and I are dinks, which is double income, no kids. So we have designated nieces and nephews as recipients.
Mhm.
And then Miss Madison wants to know a way to ask a question that might be more than she could ask a group. What's your email, Bill? She can email you.
Sure. My last name is Nolan, Nolan, at elderlawalabama.com.
Oh, and will you share the slides with me to send them out, please?
This is it at the bottom of the slide that's on here. That was what showed up when I cut and pasted.
That's so funny. But your PowerPoint, will you send it to me and I'll send it out?
Sure.
Here's a question. If someone has already done a life estate trust, did you say that cannot be changed now?
Well, it can. You would have to reach out to the people you've named as the beneficiaries of that life estate property and have them convey their interest back to you in order for you to change it. So they would basically quit claim whatever interest you gave to them back to you, and then you can do a new life estate deed, however you might want to do it.
Quit claim.
Quit, Quit, quit claim. It's a deed that says I transfer whatever I own, if anything, to whoever you have as the grantee on the deed.
Well, that was all of the questions. The password for those on YouTube and those of you who are not reading the chat is trust, which you should have guessed probably. Trust with a capital TRUST is the password. The link, again, one more time, if you missed it, is https:// www.surveymonkey.com/r/all uppercase letters with numbers K G as in girl L 9 B as in boy F as in female 9. That's our link. Our password is trust with a capital T. Thank you, as always, Bill Nolan, for being our presenter today. It was excellent. We're getting many thank yous in the chat room, and we appreciate it. And of course, we'll ask you to come back next year when we continue our series. And next, let's see, Monday, I think it's the 4th of September is when we return, and we will be doing Caring in the Home. And that will be me presenting. So something new from me on Care in the Home. Thank you, Bill, for being with us. Hope
My
everyone
pleasure.
has an excellent week and day. Have a great Labor Day holiday.
That's right.
Thank you to all of you for all the work that you do. Everyone, and thank you for being here.
Great.
Take